The final big change that I want to talk about is the pre-proof conference. This mirrors the pre-trial meeting in most respects that we already have in the Court of Session. However, the big difference is that it can be by telephone, and that makes sense because, of course, if you've got a defender in Edinburgh and a pursuer in Elgin in a case worth maybe £5,000, £6,000, £7,000, it's not really going to be economically viable for one to travel to the other to have a face-to-face meeting. So the pre-proof conference can be done over the telephone. Now the purpose is to recreate the door of court, to allow both parties to have an open discussion as to what they're looking for out of the action, what are the strengths and weaknesses of the action, and also to allow both parties to settle the case if possible. Now, the key things to remember is that whoever you take instructions for should either be with you at the pre-proof conference or should be contactable by telephone. And the second key thing I would say is that whilst the pre-proof conference has to be undertaken at least 4 weeks before the proof, with a minute lodged 3 weeks before the proof, once the defender's statement of violation of claims in, why wait? If parties are ready to settle the case, have the pre-proof conference and earlier opportunity. At the end of the day, it's in everybody's interest to settle this case as soon as possible. Secondly, I would say that if you're having a pre-proof conference in a case worth a significant amount of money, I would always recommend that you do have a face-to-face meeting. Just because you don't have to have a face meeting doesn't mean that you can't not have a face-to-face meeting, and I would certainly recommend it in the larger value cases. Now, I've got, there's a style minute for the pre-proof conference. As I said, it has to be lodged at least 3 weeks before the proof, and that's in form PI7 in the Act of Sederin, and you'll see various things are demanded, such as who's in attendance, who's available to take instructions by telephone, is a proof still required, if so what's the proof about, is it about liability, is it about quantum, is it about contributory negligence, how many days are required, and also both parties have a chance to put calls on the other side on any matters that they think fit. And finally we have quantum of damages, what has been agreed, what hasn't been agreed on the various sets of damages. The pre-proof conference minute can basically be an agenda for a pre-proof conference, and certainly from our experience in the Court of Session, the pre-proof conferences we would expect will take a lot of the unprofessional last-minute settlements out of the Sheriff Court and will allow every case to be settled in an appropriate manner in an appropriate timescale.